Alrighty, so I chose to do crimes of insanity, our most recent discussion topic that we discussed in class. Alright, I'm going to start by defining what actually is a crime of insanity, or in otherwise, an insanity plea. So it's basically a mental disorder defense in a criminal case where the defendant argues that I'm not responsible for my actions because at the time the crime was committed, I was suffering symptoms from a psychiatric disease. And this just means like I'm not responsible because I was suffering symptoms such as delusions or manic episodes. Therefore, I should not face legal consequences. I should instead maybe face psychiatric professional help. Alright, so why did I choose insanity pleas as my topic? Basically, I just thought it was interesting on how a legal system can accurately define insane. Is there specific guidelines that allow us to believe an individual is facing insanity, or is it more of a blurred line in the legal system? I also was curious to know like how much evidence is really needed. Do we need actual prescriptions? Do we need documents from mental hospitals? Or is it just through word of mouth saying maybe a doctor had said this person is insane, therefore he should not be charged? Then I also thought maybe for intense cases such as murder or maybe arson to a home or cases that are more intense, is it possible that people use this plea as an excuse so that they don't have to face consequences? Alrighty, so and then the journal article I chose was Characteristics of Successful and Unsuccessful Insanity Pleas by Carol E. Boner. Basically, she looked at the idea like what makes the plea work. Is it demographic, based on the individual's race, age, sex, maybe their criminal history, any prior hospitalizations? Is it based on the legal process, such as the trier of fact, who is making that decision of if it's a successful or unsuccessful plea? And then maybe psychological variables of the actual individual. And basically, she also challenged previous theories that insanity pleas only worked for white, rich people. And basically, this theory said if you're poor, if you're a minority, or maybe you're also from being poor, you couldn't afford a psychiatric expert, so you had poor representation, would result in it being unsuccessful. So she took subjects of 60 men that were either charged with rape, murder, armed robbery, or aggravated assault and battery. And 30 of these men had successful, not guilty by reason of insanity pleas, and then 30 were unsuccessful. Alright, so some of her findings, this is based on the demographics theory, where she basically found that demographics were not significant in determining if not guilty by reason of insanity pleas were successful or not. But what she did find was that the pleas that were successful, most of the time, the individual was found incompetent to stand trial. This table basically looks at if they use a judge or a jury and then other psychological variables that were tested by the Goldberg scale. So key points to take away from this is that successful insanity defenses were more likely to rely on a judge as opposed to a jury. In the sample, 96% of those specifically who were successful in the insanity plea never went before a jury. So meaning that if you went against a judge, you were more likely to be successful. And then also, they found that groups did not differ significantly in psychological variables. So the overall takeaways that we would get from the study is that legal process variables were the most significant variables in determining successful not guilty by reason of insanity pleas. So the two main legal processes that we found to be significant was if the individual was found to be incompetent to stand trial, they were more successful to win the plea. And then use of a judge as trier of fact as opposed to a jury would also result in them being more successful in their plea. Alright, so some critique of the research. There definitely is some limitations in the sample they used. First of all, they used all men, no females involved at all. And then they used men all from Chattahoochee, Florida, so they're all coming from the same exact legal system. I think it would have been more beneficial if they used individuals from different legal systems to see how that maybe affects whether an individual is successful and they're not guilty by reason of insanity plea. And then I thought about the ideas, Is incompetence to stand trial more likely to take place in individuals with successful not guilty by reason of insanity pleas for obvious reasons? Saying it's like, is it a natural corollary that, of course, they're incompetent to stand trial because they're severely ill, and that's why they would be successful? And then I also considered uh, there also could be an overdiagnosis in competency in individuals that were successful, and maybe they're underdiagnosing incompetency to stand trial in individuals that were found guilty. So, I mean, there could be issues in the actual system. All right, and then generalizing the results to the real world. So basically, what can we take away from this? So we could suggest that insanity pleas are more successful if the individual is found to be incompetent to stand trial and if their trier of fact is a judge. And then we also can note that demographics don't matter: race, age, gender, occupation, previous arrest records, prior hospitalizations, they don't matter according to this study. And then some other personal thoughts that maybe we could take away is that insanity pleas are found to be more successful when they are found to be incompetent to stand trial because they are simply more severely ill. So if they're found to be incompetent, it's because they're ill. That's the reason that it would be successful, because it's a real plea that it's not, as I stated before, how some people maybe use it as an excuse. It's not an excuse. Then another personal thought that I had, maybe we can take away from this, is that not guilty by reason of insanity pleas are more successful with judges, maybe because how we talked about prior in class, because juries lack proper legal knowledge. Maybe they not, such as like maybe they lack knowledge on mental illness and they don't really know what it means to be insane. Alrighty, and then what can I take away from this into the real world that can help me? So, I mean, I obviously took this class for a reason because I have interest in psychology, and then I started to get interest in law, so this is the perfect class to do that. And it makes me wonder, it just makes you understand the use of mental illness as a defense tactic can be successful. Because as we discussed in the last discussion topic, the individual was unsuccessful, and to my opinion, there was enough knowledge to prove him insane. So it kind of made me wonder, is it ever successful? But this case proved that it can be. And then helps me understand the importance of legal processes in forming a proper and fair system. Because obviously, if judges versus juries are coming out with significantly different results, there needs to be a more fair way to determine what's working, what's not. Alrighty, and then this is the article I used. Thanks for watching.